Good afternoon, everyone. Welcome to the Basic Law Education series for the Tertiary students, Seminar 1, which is held by the Hong Kong Policy Research Institute, Center of the Rule of Law. Today's topic is going to be about the backgrounds and nature of the Basic Law. After the presentation, we'll have Q&A section, so if you have any question between the presentation, you can type in chat box that in this for the Zoom function, or you can raise directly when we are in the Q&A section. So, let me have a brief introduction of the Hong Kong Policy Research Institute. So, HKPLI is established in 1995, which is a leading think tank in Hong Kong. We are also ranked for 6 consecutive years in 2015 to 2020 among the top 100 think tanks in the regions of China, India, Japan, and South Korea by the Global Go-To Think Tank Index report, the Think Tanks and Civil Society program of the Lauder Institute of the University of Pennsylvania. Some of the major events and projects conducted by us include National Security Education Day from 2018 to 2020, the Rule of Law Education Pilot Scheme for Secondary School students, the Hong Kong New Chapter Legal Summit, the 73rd anniversary of the founding of the People's Republic of China and 25th anniversary of the establishment of HKSAR, and also the Rule of Law Education Program for Secondary School students, which is now undergoing. Today's speakers will be Mr. C.M. Chen Chak-ming, who is the head of the Center of the Rule of Law, who is also the president of Law Society of Hong Kong, also a member of Law Asia Executive Committee. He is admitted in Hong Kong in 1997 and English and Welsh in 2002. So today we are going to talk about covered several things, background and nature of basic law, including with the historical context of how basic law is created, the nature of the 3 treaties that determined how we understand the history of Hong Kong and thus the basic law, the Sino-British Joint Declaration, and the One Country, Two System, the birth of the basic law, and nature of the basic law itself in terms of the international, domestic, and constitutional dimensions. So let's start from the history. If we have to talk about Hong Kong history, the legal history of Hong Kong, we have to start with the Opium War. So historically, Hong Kong had always been a part of China until the Qing Dynasty, when it was ceded to British Empire in 1842. So after losing the Opium War, China was forced to sign the Unfair Treaty. The 3 treaties include the Treaty of Nanjing, after the First Opium War. So it says the cession to Britain of Hong Kong Island. And then in 1860, we have the Convention of Peking, the Peking Convention, the Bắc Kinh條約. After the Second Opium War, then the southern tip of Kowloon is seized to Britain. And then in 1898, so the new territories is leased to Britain for 99 years until 1997, the June 30th. That's why we have the day on the 1st of July, because the lease ends at June 13th of 1997. So that's why China resumed exercise of sovereignty on 1997, July 1st. The 3 treaties, in China's perspective, are unequal treaties and thus should be invalidated under international law. According to the Article 51 and Article 52 of Vienna Convention on Law of Treaties, 1969, coerced consent shall be without legal effect. A treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations. So it is because it's under the law, because after the Opium War, China are forced to sign the treaty, so it should be invalidated. For the UK, the argument is that the Article 4 of Vienna Convention of the Law of Treaties 1969 is without prejudice to the application of any rules set forth in the present convention, to which treaties would be subject under international law independently of the convention. The convention applies only to treaties which are concluded by the state after the entry into the force of the present convention with regards to such states. So that's UK's argument. So in 1961, the UN General Assembly established the Special Committee on the Situation with regards to the implementation of the declaration on the granting of independence to colonial countries and people. So that's what we call decolonialization or self-determination. In 1972, at the request of China and based on its long-held position of status of Hong Kong and Macau as belonging entirely within China's sovereignty, the UNGA Resolution 2908 was passed to remove Hong Kong and Macau from the list of non-self-governing territories. So, in such effect, Hong Kong and Macau is not a colony under such resolution. And then, in 1982, the PRC Constitution was amended with Article 31 as the following. The state may establish special administrative region when necessary. The system to be instituted in special administrative region shall be prescribed by law and enacted by the National People Congress in the light of specific condition. So, the basic law is the law enacted by the National People's Congress for the purpose of the establishment of Hong Kong Special Administrative Region. So, the Constitution is amended in order to be ready to establish HKSAR and Macau SAR. In 1982, the British government and the Chinese government started to negotiate about how Hong Kong should be dealt with. So we can see in picture how the British Prime Minister Margaret Thatcher visited to Beijing and to negotiate how to deal with Hong Kong. In 1983, the principle of one country, two systems were agreed by the British government. And then at the end of 1984, in December 19th, the Sino-British Joint Declaration was signed. So they decided that on 1997, July 1st, they will have a transition. But in UK sense, they said it is a handover of Hong Kong. But in China, it is very clear that because even under the resolution, China still has the entire sovereignty over Hong Kong. So it's a resumption of the exercise of sovereignty of Hong Kong. So, the Sino-British Joint Declaration set out inter alia the basic policies of the People's Republic of China regarding Hong Kong. Under the principle of one country, two systems, the socialist system and policy shall not be practiced in Hong Kong's special administrative region, and Hong Kong's previous capitalist system, law and judicial system, lifestyle, and the right and obligation shall remain unchanged for the 50 years until 2047, provided that they do not contravene the basic law. The joint declaration provides that these basic policies shall be stipulated in the Basic Law of HKSAR. So the 12 basic policies of the PRC regarding Hong Kong covers the political system, economic system, judicial system, etc. And we will now go through it. So there are 12 of them. The first one is upholding national unity and territorial integrity, and taking account of the history of Hong Kong and its realities. The People's Republic of China has decided to establish, in accordance with the provision of Article 31 of the Constitution of People's Republic of China, that's what we talked about earlier, a Hong Kong Special Administrative Region upon resuming the exercise of sovereignty over Hong Kong. The second policy is that the Hong Kong Special Administration Region will be directly under the authority of the Central People's Government of the People's Republic of China. The Hong Kong Special Administrative Region will enjoy a high degree of autonomy, except in foreign and defense affairs, which are the responsibility of Central People's Government. Third point is, the Hong Kong Special Administrative Region will be vested with executive, legislative, and independent judicial power, including that of final adjudication. The law currently in force in Hong Kong will remain basically unchanged. So unlike before resuming the exercise of sovereignty, the final adjudication is not in Hong Kong, it's in UK, it's in the upper house. So now that's why we have the final court of appeal, which is the final adjudication of Hong Kong legal system. The fourth policy is that the government of Hong Kong Special Administrative Region will be composed of local inhabitants. The chief executive will be appointed by the Central People's Government on the basis of the result of election or consultations to be held locally. Principal officials will be nominated by the chief executive of the HKSAR for appointment by the Central People's Government. Chinese and foreign nationals previously working in the public and police service in the government departments of Hong Kong may remain in employment. British and other foreign nationals may also be employed to serve as advisor to hold certain public posts in government departments of Hong Kong Special Administrative Region. Number 5. The current social and economic system in Hong Kong will remain unchanged, and also will the lifestyle, rights and freedom, including those of the person, of speech, of the press, of assembly, of association, of travel, of movement, of correspondence, of strike, of choice of occupation, of academic research, and of religious belief will be ensured by the law in HKSAR. Private property ownership of enterprise, legitimate right of inheritance, and foreign investment will be protected by law, and which are now all protected by the Basic Law. The sixth point is that the Hong Kong government, HKSAR, will retain the status of a free port and a separate custom territory. Number 7. The Hong Kong Special Administrative Region will retain the status of an international financial center, and its market of foreign exchange, gold, securities, and futures will continue. There will be free flow of capital. The Hong Kong dollar will continue to circulate and remain freely convertible. Number 8. The Hong Kong Special Administrative Region will have independent finances. The Central People's Government will not levy taxes on Hong Kong Special Administrative Region. Number 9. The HKSAR may establish mutually beneficial economic relations with the United Kingdom and other countries, whose economic interests in Hong Kong will be given due regard. 10. Using the name of Hong Kong, China, the Hong Kong Special Administrative Region may on its own maintain and develop economic, and cultural relations and conclude relevant agreements with states, regions, and relevant international organizations. The government of Hong Kong Special Administrative Region may on its own issue travel documents for entry into and exit from Hong Kong. 11. The maintenance of public order in Hong Kong Special Administrative Region will be the responsibility of the government of HKSAR. And last but not least, the above stated basic policies of the People's Republic of China regarding Hong Kong and the elaboration of them in Annex 1 of the Joint Declaration will be stipulated in a basic law of Hong Kong Special Administrative Region of the People's Republic of China by the National People's Congress of the People's Republic of China and will remain unchanged for 50 years. Just mentioned, the 12th basic policy, the last one, talks about all those basic policies, and the Annex 1 to the Joint Declaration will be stipulated in the basic law of Hong Kong SAR by the National People's Congress of the PRC. So it is obvious that the source of law of the basic law came from the National People's Congress. So this is how we should understand the birth of the basic law. So if we look back at the history that we just talked about, we can see obviously, very clearly, that the constitutional basis of the HKSAR came from the Article 31 of the Constitution of the PRC, which, as I just talked about, the state may establish special administrative region when necessary. The system to be instituted in special administrative region shall be prescribed by law and acted by the National People's Congress in the light of special conditions. And also, we can look at the Article 62, Section 13 of the Constitution of PRC to decide on the establishment of special administrative region and the system to be instituted there. So it is the setting up of the HKSAR is by the power of PRC from the Constitution. Decision of the National People's Congress on the basic law of Hong Kong Special Administration of the People's Republic of China. It's adopted at the third section of the 7th National People's Congress in 4th of April 1990s. So it's also specified that the third section of the 7th National People's Congress has adopted the basic law of Hong Kong Special Administrative Region of the People's Republic of China. Article 31 of the Constitution of the PRC provides the state may establish special administrative region when necessary. Is what we just talked about. The system to be instituted in special administrative region shall be prescribed by law and acted by the National People's Congress in the light of specific condition, and such the system, policies, and law to be instituted after the establishment of Hong Kong Special Administrative Region shall be based on the basic law of Hong Kong Special Administrative Region. So, which is very clear. So, how the law is designed and how basic law is designed and we talk about the legal history of how it is, how the source of law and why we have the basic law. So how is it written? How is it drafted? So in 1985 April, so members from both Hong Kong and mainland, they composed a basic law drafting committee. So a basic law consultative committee was formed by Hong Kong people, was established in 1985 to canvass views in Hong Kong on the draft. It produced 2 preliminary drafts and 1 final draft. So there's a widespread public consultation also. The basic law was formally promulgated on 4th of April 1990 by the National People's Congress of the People's Republic of China. On the 1st of July 1997, the Basic Law came into effect, replacing the British document, the letter patent, and the royal instruction. So after that, UK played no roles in drafting the Basic Law. Let's talk about the nature of the Basic Law. The Basic Law comprised 9 chapters, 160 articles, and 3 annexes. So, according to the Court of Final Appeal in the case of Nkaling versus Director of Immigration 1999, the Basic Law is a national law and is the constitution of the region. And if we look at 1997 HKSAR versus Ma Wai Kwan David, the Basic Law is a unique document. It reflects a treaty made between 2 nations. It deals with the relationship between the sovereign and an autonomous region, which practice a different system. It stipulates the organization and functions of the different branches of government. It set out the rights and obligations of the citizen, and hence it has at least 3 dimensions: international, domestic, and constitutional. So let's first look at the international dimension in terms of the Sino-British Joint Declaration. It was adopted by Hong Kong courts that the Sino-British Joint Declaration could be referred to so as to interpret the article of Basic Law. So according to the case we just talked about, the Nkaling versus Director of Immigration, the international dimension is not relevant today as the provisions of the Sino-British Joint Declaration have been fully implemented and the declaration has become a non-binding historical document according to the central government. For the domestic dimension, China and the HKSAR relationship is the domestic dimension. And according to Chapter 2 of the Basic Law, relationship between the central authorities and the Hong Kong Special Administrative Region set out the framework and rules which describe and prescribe the executive and power structure within the context of one country, 2 systems. So there are a few important provisions. Let's go through it. Article 12 is that the Hong Kong SAR shall be a local administrative region of the People's Republic of China, which shall enjoy a high degree of autonomy and come directly under the Central People's Government. Article 13 talks about the Central People's Government shall be responsible for the foreign affairs related to HKSAR. Article 14 talks about the responsibility of defense of Hong Kong SAR is by the Central People's Government, and the government of HKSAR shall be responsible for maintenance of public order. Article 15 is about the appointment of chief executive and the principal official of the executive authority of the HKSAR should be appointed by Central People's Government in accordance with the provision of Chapter 4 of the law. Article 20 is about the HKSAR may enjoy other powers granted by the National People's Congress, the Standing Committee of the National People's Congress, or the Central People's Government. Article 22 talks about no departments of Central People's Government and no province, autonomous region, or municipality directed under the central government may interfere in the affairs which the HKSAR administers on its own in accordance with this law. Some more important Basic Law articles that we should have a look at. So Article 1, the Hong Kong Special Administrative Region is an inalienable part of People's Republic of China, so which is stated at the first articles, very clearly state the relationship between HKSAR and People's Republic of China. Article 2, the National People's Congress authorized the Hong Kong Special Administrative Region to exercise a high degree of autonomy and enjoy executive, legislative, and independent judicial power. including that of final adjudication, in accordance with the provision of this law. So it very clearly clarifies the relationship between the HKSAR and also the the National People's Congress. Article 5 states clearly that the socialist system and policy shall not be practiced in Hong Kong, SAR, and the previous capitalist system and way of life shall remain unchanged for 50 years, so which is what we talked about in the Sino-British Joint Declaration. Rule 8 talks about the law previously enforced in Hong Kong, that is the common law, rule of equity, ordinances, subordinate legislation, and customary law shall be maintained except for any that contravene this law and subject to any amendment by the legislature of Hong Kong SAR. Article 9. In addition to the Chinese language, English may also be used as an official language by the executive authorities, legislature, and judiciary of the Hong Kong SAR. Article 11. In accordance with Article 31 of the Constitution of the People's Republic of China, the system and policies practiced in HKSAR, including the social and economic system, the system for safeguarding the fundamental rights and freedoms of its residents, the executive, legislative, and judicial systems, and the relevant policies shall be based on the provision of this law. No law enacted by the legislature of Hong Kong SAR shall contravene this law. So we can see all those that discussed it previously about Sino-British Joint Declaration, how they negotiate, what is protected, and how Hong Kong should work with the one country, two system is all inscribed in the basic law. So, besides the domestic dimension of the basic law, we should also look at the constitutional dimension of basic law. The basic law has been referred to as a constitutional document of Hong Kong, as it had set out basic rights and obligations of Hong Kong citizens, provide quasi-constitutional level of protection to citizens' freedom, and also stipulated the power structure of the executive, legislative, and judicial arms of the city. In Galing versus Director of Immigration, as we mentioned quite a few times today, it was adopted that the basic law is the constitution of the region. However, according to Article 12 of the basic law, Hong Kong comes directly under the central people's government. In addition, the basic law could only be effective within a PRC constitution that permits it. So, one country, two system, we have to bear in mind, is not a federal system, as the Chinese government adopts a unitary system, such as the basic law should be a subordinated constitutional document, or called 子法, rather than a constitution itself. We've gone through quite a lot today, so let's do some summing up. The first point is, the Article 1 of the Basic Law stated, Hong Kong is an unalienable part of China. Basic Law is a constitutional document that lays out principles of one country, two systems. Its constitutional documents should not be understood as a constitution. The socialist system is not applicable in Hong Kong, which continues its capitalist way of life. The system will remain unchanged for 50 years. The law previously enforced in Hong Kong shall be maintained. Hong Kong enjoys high degree of autonomy. The PRC Constitution provides the basic law and the establishment of the HKSAR constitutional basis. The basic law has three dimensions: international, domestic, and constitutional. The power of final adjudication of the HKSAR should be vested in the Court of Final Appeal of the region, which may, as required, invite judges from other common law jurisdiction to sit on the Court of Final Appeals. So this is all the content that we think we should go through on the Seminar 1. Do you have any question about the content or other things that we've gone through? So please type in to the chat box, or you can open your mic. If not, I think we will call it a day. This is the Seminar 1 of the Hong Kong Policy Research Institute Basic Law Education Program for Tertiary students. So our next seminar will be on 17th of January, which is next week. So please be punctual and remember to check your email for the Zoom link. And I will see you next week. Thank you so much.